Section 1 of The Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. Chapter 4, Campaign Financing. Introduction. One of the principal areas of interest to the Select Committee was the financing of the various presidential candidacies. As the candidates of their respective parties, President Nixon's and Senator McGovern's campaigns ultimately compiled total expenditures of over $100 million. The unsuccessful campaigns of others seeking nomination spent millions of dollars more. The report that follows reviews some of the more significant subjects investigated by the committee, including alleged corporate contributions by 13 corporations. In 12 cases, the corporation or one of its officers have pleaded guilty. The relationship between campaign contributions to FCRP and the interest of the contributors in securing ambassadorships. Union activity in the campaign. The role of Herbert W. Kalmbach in fundraising, the contribution of Robert Allen, whose funds became the so-called Mexican checks, an incident involving FCRP's National Hispanic Finance Committee, the results of the committee's questionnaires, the corporate-oriented campaign of FCRP, the settlement of campaign debts in the campaign of Senator McGovern, and the receipt of certain cash contributions by the campaign of John V. Lindsay. The 1972 campaign, particularly that of President Nixon, was in effect split into two by the April 7, 1972 effective date of the Federal Election Campaign Act of 1971. Prior to April 7, 1972, contributors could be assured that their contributions would remain confidential. Based on this understanding, large contributions were made, including many in cash and some out of corporate assets. Significantly, almost all of the largest corporate contributions were made before April 7, 1972. Furthermore, one of the results of the fact that a large number of contributions were given in cash was difficulty in tracing the source of the funds. Although hundreds of persons were interviewed and tens of thousands of documents examined in connection with this phase of the investigation, it was not possible, of course, to investigate fully every allegation or question every contributor of a substantial sum. In its effort, the committee staff was assisted by the Government Accounting Office and its Office of Federal Elections. Based on the results of its investigations, the committee has made a number of recommendations emphasizing the importance of citizen participation, disclosure, and accountability. 1. Corporate contributions. During the 1972 presidential campaign, it appears that at least 13 corporations made contributions totaling over $780,000 in corporate funds. Section 610 of Title 18 United States Code prohibits contributions on the part of corporations and unions. Of these, 12 gave approximately $749,000 to the president's re-election campaign, which constituted the bulk of the illegal corporate contributions. While there is no evidence that any fundraiser for President Nixon directly solicited a corporate contribution, there is evidence that a number of them either were indifferent to the source of the money or, at the very least, made no effort whatsoever to see to it that the source of the funds was private rather than corporate. In any event, there is no evidence that any fundraiser who was involved in these contributions sought or obtained assurances that the contribution was legal at the time it was made. There is no clear pattern to the solicitations that led to corporate contributions. Thus, a number of fundraisers solicited contributions that turned out to be corporate. Other contributions solicited by these same individuals gave all the appearance of being totally legal. Some of these solicitations were vigorous. Some were low-key, to the point where the contribution can be considered voluntary. The sources of the corporate money were also varied. The single most utilized source of corporate funds was foreign subsidiaries. Corporate funds obtained by this means included corporate reserves of apparent long standing. Others give indications of being isolated transactions, with the funds accumulated in response to the solicitation in question. Another pattern included the use of corporate expense accounts and corporate bonuses to reimburse corporate executives for their contributions. In most cases, there was apparently a contemporaneous understanding at the time the contribution was made, or, in fact, the corporate reimbursement actually preceded the contribution. Finally, in the great majority of cases, the contributions were in the form of cash, which on several occasions was generated very rapidly by the donor. Although the bulk of the contributions preceded April 7, 1972, the date the new reporting law, Federal Elections Campaign Act of 1971, went into effect, there was no disclosure of the corporate nature of any contributions until July 6, 1973, or 15 months after most of them were made. The main impetus to the disclosure came from the imaginative suit brought by Common Cause to compel disclosure of pre-April 7th contributions. When it became apparent that some sort of disclosure by the Finance Committee to re-elect the President would be required, letters were sent out by FCRP seeking enumeration of the individuals who had actually made the contributions. The responses varied. In some cases, the corporate executives prepared a list of employees, either with or without their consent, that was false. Other executives promptly called in attorneys who advised them to make full disclosure, which was done. According to the evidence, in at least 2 cases, American Shipbuilding Company and Northrop Corporation, elaborate schemes to conceal the corporate nature of a contribution were indulged in, and involved lying to the FBI. There follows a summary of the committee's investigation into alleged and admitted corporate contributions. A. American Airlines Incorporated. In March 1972, following a solicitation by Herbert Kalmbach, the personal attorney for the President, and also a counsel to United Airlines, American Airlines Incorporated made a contribution from corporate funds in the amount of $55,000. As related in public testimony by George A. Spater, former chairman of the board and chief executive officer of American Airlines, he first met Kalmbach in March 1971, but no solicitation occurred until July 30, 1971, when Spater was asked by Daniel Hofgren, vice chairman of FCRP, to join him and Kalmbach for lunch. During that luncheon, there was no specific request for a contribution, although Kalmbach's role as a fundraiser was mentioned. Following the luncheon, Spater, anticipating that he would be getting a request from Kalmbach for a substantial contribution, and having heard that FCRP was searching for $100,000 givers, asked an American Airlines official to assemble $100,000. 2 or so months later, Kalmbach called Spater, and the two of them had dinner in New York on October 20, 1971. At this dinner, Kalmbach asked for a contribution in the neighborhood of $100,000, advising Spater that this would put him in a special class. Spater replied that he would do his best to produce $70,000 or $75,000. Kalmbach said that he hoped Spater would do better. As described by Spater, Kalmbach was less than enthusiastic about Spater's response to his request of $100,000. No mention of cash was made in this discussion. Spater stressed that he would have preferred making the whole contribution in a way that would have been unobjectionable, but I wasn't able to do that. When Spater was asked whether he drew the inference from what Kalmbach had said that he was trying to get $100,000 from Spater personally, Spater replied that it never entered my mind that he was, because I simply do not have the capacity to do it, but that is a subjective evaluation. Following this request, and while the corporate money was being generated, Spater obtained a series of $5,000 checks from a friend, had those checks converted to cash, and arranged for a series of $5,000 donations in $100 bills to be made to FCRP between December 1971 and February 1972. Meanwhile, Spater's colleagues arranged for a check in the amount of $100,000 to be drawn on American's account at the Chemical Bank, which was transmitted to a Swiss account of a Lebanese agent, Andrei Taborian, whom American had utilized in more traditional business enterprises. The $100,000 was charged on American's books as a special commission to Andrei Taborian in connection with used aircraft sales to Middle East Airlines. After the money was transmitted to Switzerland, it was transferred back to the United States to an account maintained at the Chase National Bank in New York. Later, the Lebanese agent came to New York, went to the bank, obtained the $100,000 in cash, and gave it to an American Airlines official who returned to the office and placed it in an office safe. In March 1972, with $15,000 already having been contributed to FCRP and $5,000 more from the same source in hand, Spater arranged for $55,000 in corporate funds to be removed from the safe. As in prior instances, the money in $100 bills was put in an unmarked envelope and delivered either to Lee Nunn or Hugh Sloan at FCRP. Aside from this contribution, Spater admitted that an American Airlines employee, while on the company payroll, had worked for Democrats for Nixon. This corporate contribution involved an additional $10,000. More than a year later, on about April 26, 1973, Spater received a telephone call from Kalmbach, who stated that Stans was saying that in view of the common cause suit against FCRP, it might be necessary to release information concerning contributors, and if this were done, American Airlines would be shown as having given $75,000. Apparently, Kalmbach was not seeking information, and Spater did not tell him anything about the source of the funds. After receiving additional calls concerning the possibility of disclosure, Spater went to counsel and, following discussions, agreed to admit to the illegal contribution. On July 6, 1973, American Airlines became the first corporation to make disclosure of a corporate contribution in a 1972 campaign. Thereafter, the $55,000 in corporate funds was returned from FCRP, and the entire $100,000 returned to proper corporate channels. While noting that there was no quid pro quo involved, Spater testified at some length to the circumstances which led him, a lawyer and former general counsel for American Airlines, to participate in the illegal transaction. During the time of the solicitation by Kalmbach, American had numerous matters pending before various agencies of the federal government, including approximately 20 of substance. Spater noted that it is not unusual for American to have a substantial number of significant matters pending with the government. Among the pending items was a proposed merger between American and Western Airlines. Spater noted that the merger agreement expired in February 1972, and it had been extended about 3 or 4 times. Spater had heard rumors to the effect that the White House was opposed to the merger. The final decision, Spater noted, was in the hands of the President himself. In late May or June, 2 or 3 months after the final installment was delivered to FCRP, Spater turned to Stans, former Commerce Secretary and Chairman of FCRP, for information concerning the White House position. Spater testified that he turned to Stans because I did not know anybody in the political arena at the White House. Stans never provided him with any information. Ultimately, the merger was not authorized. Although Spater acknowledged that Kalmbach never threatened him and the merger and other American Airlines problems were never discussed, Spater was apprehensive of the solicitation, particularly in view of the fact that Kalmbach was not only the attorney for American's principal competitor, United Airlines, but was the President's personal attorney. Spater expanded on this theme in response to questions from Senator Ervin. Senator Ervin: Now, here in these circumstances, Mr. Kalmbach came in and said he wanted a contribution of $100,000, and he hoped that it would be received, and all those who made a contribution of as much as $100,000 would be put in some kind of select class. Mr. Spater: Yes, sir. Senator Ervin: Well, didn't you interpret that as a sort of implied promise, as far as Mr. Kalmbach could make one, that people who had made contributions of $100,000 would have a superior consideration to people who were not able to make contributions of that much? Mr. Spater: Well, there was the other possibility, and that was a negative one, which was very much in my mind. I think, as a result of the hearings before this committee, it probably might be something, and that is that you would be regarded as a persona non grata if you didn't. There were two aspects. Would you get something if you gave it, or would you be prevented from getting something if you didn't give it? Senator Ervin: In other words, to use the vernacular expression, a request of this kind has a tendency to instill the fear that if you don't comply, you might get, in the use of the vernacular, get it in the neck from some government agency. Mr. Spater: Yes, Mr. Kalmbach, of course, is a lawyer for our principal competitor, who was opposing us in the merger case, so I didn't believe that giving him the money would help us in that case. Senator Ervin: But you did fear that if you didn't give the money there might be some consequences? Mr. Spater: Yes, sir, I was worried. Senator Ervin: Departing from the normal use of language, would it not be fair to say that requests of people of high authority who control great government power, or who have direct access to those who control great government power, when they ask for contributions, there is a sort of unspoken coercion in the request, isn't there? Mr. Spater: Unspoken what, sir? Senator Ervin: Does not a request for a campaign contribution of persons from industries or the officers of industries that are particularly subject to government regulation have the effect, although there is no coercion spoken, but they have the effect of some kind of implied coercion, don't they? Mr. Spater: Yes, sir. I explained it when I was talking to counsel of the staff, that it is something like the old medieval maps that show a flat world and then what they call terra incognito, with fierce animals lying round the fringes of the map. You just don't know what is going to happen to you if you get off it. I think sometimes the fear of the unknown may be more terrifying than the fear of the known. I think this is a very large element of the picture. Under questioning from Senator Montoya, Spater added: Senator Montoya: You did not, during your 3 conversations with Mr. Kalmbach, give any slight thought to the possibility that he was trying to obtain from you a voluntary contribution for $100,000, with the emphasis on the voluntary? Mr. Spater: No, I do not think he would have introduced this idea of a special class, nor would he have approached me from that point of view. As a possible solution, Spater proposed restrictions on solicitation on the part of certain former high government officials. I believe that the present system places unfair pressures both on candidates and on corporate executives. As I said in my statement of July 6th, most contributions from the business community are not volunteered to seek a competitive advantage, but are made in response to pressure for fear of the competitive disadvantage that might result if they are not made. This process degrades both the donor and the donee. It is particularly dangerous when the pressure is implicit in the position of the individual making the solicitation. I suggest, therefore, that congressional consideration be given to the advisability of making certain individuals wholly ineligible to engage in campaign solicitation. In particular, I recommend that solicitation by individuals who are personal representatives of officers holding such positions be made unlawful. End of Section 1. Recording by Maria Casper. Section 2 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. Chapter 4, Campaign Financing, Part 2. B. American Shipbuilding Company. On April 6, 1972, Ronald H. Slater, an official of the American Shipbuilding Company, delivered $100,000 to the offices of the Committee to Re-elect the President. Company officials have testified that at least $25,000 of that money came from corporate funds. The remaining $75,000 is credited to George M. Steinbrenner III, Chairman and Chief Executive Officer of the company, although the source of these funds has not been ascertained. According to the testimony of Robert Melcher, counsel to American Shipbuilding, Thomas Evans, an attorney with the firm of Mudge, Rose, Alexander and Guthrie, and the deputy director of the Finance Committee to Re-elect the President, introduced Steinbrenner to Kalmbach in Washington. Melcher testified, "Mr. Steinbrenner told me that he said that Mr. Kalmbach said that he would like to have Mr. Steinbrenner make a contribution to the Committee to Re-elect the President, and as I further recall what Mr. Steinbrenner told me, that Mr. Kalmbach had indicated to him that the Republicans were, I think I quote him, going to win big this year, and that while he was aware of and was sorry about the fact that the OSS claim had been turned down, that was water over the dam, and that he apparently also made reference to the fact that Mr. Steinbrenner had been active in Democratic politics. I believe he ran the Democratic Congressional Dinner Campaign in 1969 and 1970, and that it would be appropriate for Mr. Steinbrenner to, I think he said, get on the right team or something like that. We are going to be around here for the next 4 years, and you ought to get with the right group." And then I think Steinbrenner asked, well, now, what kind of a contribution do you want? I mean, what is appropriate? And Mr. Kalmbach said that there were various, apparently, categories of contributions, and I gather these were in sort of $25,000 increments. And I gathered from that there was an indication that in order to have any, and these are Steinbrenner's words, input into the administration, there would be a need to make a very substantial contribution. Well, I think he said that there were some people that were contributing $250,000. Others were contributing $500,000. And I think Steinbrenner said to me that it would, or he got the impression anyway, whether Kalmbach actually said this or not, I don't know. Obviously, I wasn't there. But that it would take $100,000 to get into the select group or whatever. Senator Ervin: "The special class was the term?" Mr. Melcher: "Well, whatever, Senator, I don't recall. But that was the gist of what Mr. Steinbrenner related to me of his conversation with Mr. Kalmbach. I might add one other thing, Mr. Mayton, and this is a paraphrase, and it may be totally improperly stated, but this is the substance of it, that they would be happy to receive any contribution, but that if you were in the $25,000 class, or you were in the $50,000 class, you would be amongst many, many thousands, and that you probably would be lost in the shuffle and wouldn't be remembered." At the time of this solicitation, American Shipbuilding was involved in two major matters with the government. In the first, the company was seeking $5.4 million in construction cost overrun for the Oceanographic Survey Ship Researcher, which was referred to previously as the OSS claim. This claim was denied by Maurice Stans on February 11, 1972, 4 days before he left his post as Secretary of Commerce. The company appealed to his successor, Peter G. Peterson, without success. A partial settlement was reached on May 2, 1972, pursuant to which American Shipbuilding paid $230,000 in late delivery and construction penalties. The government did, however, excuse more than half of the 99-week delay penalties that could have been imposed. The second matter involved an antitrust suit which was filed by the Justice Department in August 1972. The suit sought to block the purchase of 9 bulk cargo ships which operated on the Great Lakes. The government charged that, if allowed, this acquisition would give American Shipbuilding almost total control of grain shipping operations on the lakes. The acquisition was finally allowed with certain stipulations. The settlement, while not altogether beneficial to American Shipbuilding, has given the company substantial control of the grain shipping market on the Great Lakes. In 1970, according to Robert E. Bartlome, corporate secretary, and Stanley J. Lepkowski, treasurer and comptroller, Steinbrenner advised them that he had been under some pressure to make political contributions. He explained to them that many companies secured funds for contributions through the granting of bonuses to employees who then made those proceeds available to the company. Lepkowski voiced some objections to this scheme, but after assurances from Steinbrenner, a bogus bonus plan was adopted. The three men drew up a list of 6 trusted employees to receive bonuses, including Lepkowski and Bartlome. Steinbrenner was the only person with the authority to grant bonuses, and in September 1970 he appears to have authorized the first of a series of bonuses. In late March or early April 1972, Bartlome related, Steinbrenner advised him that $25,000 was needed for an unspecified contribution. After some discussion between the two, it was decided that the bonus list had to be increased to 8 employees. Since one official had left the company, 3 names were added to the list. In addition to Bartlome and Lepkowski, the bonus list now included Robert Clark, Robert Dibble, Gordon Stafford, Ian Cushman, Dan Kissel, and Roy Walker. On April 5th or 6th, Steinbrenner supplied Bartlome with a list of Nixon re-election committees and authorized $5,000 bonuses. In addition, he gave Bartlome the name and address of the person to whom the donations were to be delivered, Herbert Kalmbach, at 1701 Pennsylvania Avenue. On the morning of April 6, 1972, Bartlome contacted each of the people on the bonus list. As in previous transactions, they were given their bonus checks, in this case $5,000, and then asked to write personal checks of generally about $3,000. He also furnished each person with a slip of paper indicating the re-election committee to which their check was to be written. Bartlome collected checks totaling $25,000 and placed them in an envelope that already contained $75,000 in $3,000 checks given to him earlier by Steinbrenner. Bartlome gave the envelope containing $100,000 to Slater for delivery. Slater arrived at Kalmbach's office early in the afternoon of April 6, 1972, and left the envelope with the secretary. Slater later confirmed that Kalmbach had received the donations. The $40,000 in bonuses was charged against the Maritime Administration's claim cost amount for the OSS researcher. Lepkowski testified that this type of cost, although carried on the books as a receivable against OSS Marad account cost claim, would not normally be presented for payment, but would rather be taken as a deduction for tax purposes. He did concede, however, that it was possible for this claim to be presented to the Maritime Administration for payment. In either case, the government, and ultimately the taxpayer, would be picking up at least part of the cost. In January 1973, Steinbrenner became concerned about the bogus bonus payment after a news reporter began questioning some of the purported contributors. According to Bartlome and Lepkowski, Steinbrenner asked them to arrange a legitimate bonus payment plan to help camouflage the April 1972 transaction. A dozen employees, including 4 on the previous list, were given bona fide bonuses. Bartlome was asked to have the 1972 and 1973 bonus recipients sign a certificate prepared by Melcher. This certificate stated that the bonus received was bona fide and not connected with any political contribution. The 1972 recipients were asked to backdate their signatures to December 1971. On or about August 1, 1973, Steinbrenner apparently instructed Bartlome to prepare 3 backdated memos purporting to represent bonuses since 1970. The purpose of these memos was to further camouflage the bonuses by adding some backup material. The memo granting the April 1972 bonus is dated April 5, 1972, and states, Mr. George M. Steinbrenner III today determined that the Amship Division had performed in an extraordinary manner
and determined that the following receive the bonuses approved in the November 11, 1971 Board of Directors meeting. It then listed Bartolome, Lepkowski, Cushman, Kissel, Clark, Stafford, Walker, and Dibble. All the bonuses were in the amount of $5,000. Bartolome testified he maintained a record of the receipts and disbursements until, one day, it was in my office, Mr. Steinbrenner was shown the records for some reason. Later, he contacted Mr. Lepkowski, and a meeting was scheduled that afternoon. He asked Mr. Lepkowski to bring any records that we might have at Lorraine which would show the bonuses and the distribution of the bonuses and the dates. Mr. Dash: Do you recall about when this was that you were asked to turn over all these records to Mr. Lepkowski, and he took them over to Lorraine and to Mr. Steinbrenner? Mr. Bartolome: To the best I can recall, it was April of 1973. Mr. Dash: Do you know what happened to those records? Mr. Bartolome: Mr. Lepkowski advised me that Mr. Steinbrenner destroyed the records. In August 1973, the difficulties increased. In an executive session, Bartolome related that, a couple of days prior to August 23, 1973, we were advised by Mr. Steinbrenner that the FBI would be in to interview us, that it was a routine information-gathering venture, that it would not be under oath, our testimony would not be sworn to. At that time, he related a story to the effect that the group of employees, among many others, had had several conversations in which they had determined to make political contributions, that I had approached Mr. Steinbrenner suggesting that he advise us in the manner in which these contributions could be made. He had told us that if the contributions were small, they should be made to a local Republican party, that if they were a large contribution, that he would provide us a list of committees to which contributions could be made, and that he would advise us how to get the checks down to Washington. Mr. Mayton: Who gave you those instructions? Mr. Bartolome: Mr. Steinbrenner. They were not instructions. They were related to us, or informed us, to a way that our testimony would be given to the FBI. In public session, Bartolome expanded upon his earlier testimony. Mr. Dash: Did you, in fact, give this kind of statement to the agents of the FBI? Mr. Bartolome: Yes, I did. Mr. Dash: Would you look at Exhibit 271-10? That appears to be a statement dated August 23, 1973, Lorraine, Ohio, a statement at the end of which it is attested, I have read this statement consisting of this and 6 other pages, initialed each page and each correction. This statement is true and correct to the best of my recollection. It is signed by Robert E. Bartolome. Is this the statement or a copy of the statement that you gave to the FBI? Mr. Bartolome: Yes. Mr. Dash: In effect, this was a false statement? Mr. Bartolome: Yes. Mr. Dash: Did you show this statement to any of the other employees? Mr. Bartolome: We exchanged statements among us after we, Mr. Lepkowski and I, had been interviewed. Lepkowski acknowledged that he had also signed a similar statement on the 23rd. According to Matthew Clark, a day or two later he had a conversation with Steinbrenner. At that time, Clark recalled, Mr. Steinbrenner mentioned that the FBI would be interviewing us, the other 6 contributors, about our contributions, and that Mr. Melcher, our corporate lawyer, would be talking to us about it further. Clark testified that he was subsequently contacted by Melcher and told that we would be questioned by the FBI and to tell them that my wife and I had decided on our own to donate the money to re-elect the president. I mentioned to Mr. Melcher that I did not want to involve my wife, and I would not, but I would say that I had decided to do this. Mr. Melcher had in his possession previous statements by Mr. Bartolome and Mr. Lepkowski. Mr. Dash: Did he show them to you? Mr. Clark: Just by holding them up in front of me and saying reports by Mr. Lepkowski and Mr. Bartolome, and I want you, after you are through here, to go down and take a look at them to get an idea of what they had said. Mr. Dash: And what impression did you get from that recommendation? Mr. Clark: Well, the impression I got, he had mentioned that we should say that we gave the donation because of President Nixon's involvement in the shipping industry, and to help the shipping industry to get an idea of what vein the other fellows had made the... Mr. Dash: In other words, would it be fair to say what he was suggesting to you was that your stories should be the same, or approximately the same, that you were giving a voluntary contribution out of your own funds, and that it was for President Nixon's re-election because of what he had done for the shipping industry? Mr. Clark: Yes. Mr. Dash: Now, did you, in fact, go and read Mr. Bartlome's and Mr. Lepkowski's statements? Mr. Clark: I went down and contacted Mr. Bartlome. He did not have this report there. I then went and saw Mr. Lepkowski. He did have his report. I did read it in Mr. Lepkowski's presence and returned it to him. Mr. Dash: Then you were interviewed by the FBI agents? Mr. Clark: Yes. Mr. Dash: And did you, in fact, give the kind of statements that Mr. Melcher and Mr. Bartlome and Mr. Lepkowski indicated that you should give? Mr. Clark: Similar, yes. The remaining 5 contributors were also interviewed by the FBI, and each one gave and signed a similar statement. At least some of the others talked to Melcher or Steinbrenner, and all were aware of the previous statements given to the FBI by Lepkowski and Bartlome. Between August 31, 1973 and September 3, 1973, subpoenas were issued by the Watergate grand jury to each of the 8 contributors. The subpoenas called for an appearance on September 5, 1973. Clark was the first to receive a subpoena, and he notified Melcher, who notified Steinbrenner. At 11 p.m. on August 31st, Steinbrenner called Bartlome into the office for the first of a series of meetings prior to the scheduled September 5th grand jury appearance. Bartlome describes these meetings. Mr. Bartlome: He told me that Mr. Clark had received a subpoena and was to appear before the grand jury on September 5th, that we probably all would be receiving subpoenas, but he would not have to go before the grand jury. He again recalled the story, which was basically the same as in the FBI interview statement. Mr. Dash: In other words, in this meeting, he restated to you in his own words the so-called story, the fact that there was a meeting and that all the employees had on their own decided to give contributions for the re-election of the president and out of their own funds. Mr. Bartlome: Yes. Mr. Dash: What did you say to Mr. Steinbrenner at that time, if anything? Mr. Bartlome: It was my feeling from the conversations with these gentlemen that they would not perjure themselves if they went before the grand jury. Mr. Dash: Did you say anything about what you would do? Mr. Bartlome: I said I would not perjure myself. Mr. Dash: Did you again meet with Mr. Steinbrenner on September 1st, which was the very next day? Mr. Bartlome: Yes. Mr. Dash: Was there anything of particular note in that conversation? Mr. Bartlome: Same conversation. Mr. Dash: Same thing. Mr. Steinbrenner again sort of renewing his recollection, or at least what he would like it to be, of the story he told to you. Mr. Bartlome: His recollection of what happened on the granting of bonuses. Mr. Dash: Did you dispute that with him, or did you understand that to be an effort just to try and get the story straight? Mr. Bartlome: At one of the meetings here in the next 2 or 3 days, I did discuss with him what I felt to be the truth. Mr. Dash: Apparently on Labor Day there was a meeting about which we have already heard testimony from Mr. Clark. You attended that meeting? Mr. Bartlome: Yes. Mr. Dash: That was September 3rd. Who else was there? Mr. Bartlome: Mr. Clark, Mr. Lepkowski, and myself. Mr. Dash: This was a meeting with Mr. Steinbrenner? Mr. Bartlome: Yes, it was. Mr. Dash: Can you briefly tell us what was discussed, what Mr. Steinbrenner said, and what was said by others at the meeting, including yourself? Mr. Bartlome: I told him I could not testify as to the accuracy of the FBI statement, that the rest of the fellows would not perjure themselves, and we were told, "Don't worry, you won't have to go before a grand jury." Mr. Dash: In other words, Mr. Steinbrenner told you you don't have to worry about anything, you won't have to go before the grand jury. Mr. Bartlome: That is right. On September 4th, the day before the scheduled grand jury appearance, Steinbrenner, Melcher, Lepkowski, McMahon, and Bartlome met. Mr. Dash: What did Mr. Steinbrenner say at that meeting? Mr. Bartlome: Basically, he related the same recollection as to how the contributions were made and why they were made, that they were large and small, how they would be made and distributed. He remembered that on the bonus list there were only 2 of the gentlemen, not the 8, and that very likely he would recollect there would be payment of the bonus up to April 6th, authorizing payment up to April 6th. Mr. Dash: What did you say at that meeting? Mr. Bartlome: I told him that this was not the way it was handled, and I again mentioned at this meeting that the gentlemen, it was my feeling, that they would not perjure themselves, but would tell the truth before the grand jury. Mr. Dash: Now, did Mr. Steinbrenner react to that when, in fact, did somebody at that meeting say, "Finally, we learned the truth"? Mr. Bartlome: That was the following meeting, with Mr. McMahon and Mr. Melcher. Mr. Dash: Was Mr. Steinbrenner at that meeting? Mr. Bartlome: The same date. Mr. Dash: Mr. Steinbrenner was at that meeting. Mr. Bartlome: Yes, he was. Mr. Dash: And did Mr. Steinbrenner make any statement of reaction to the fact that the truth might come out? Mr. Bartlome: I was questioned by Mr. McMahon and related to him what I felt was the true story, and he said something to the effect, "Well, now we have finally learned the truth." Mr. Dash: And what did Mr. Steinbrenner say? Mr. Bartlome: Mr. Steinbrenner was distraught, and I believe he did not change his recollection of what happened at that time. The September 5, 1973 grand jury appearance was postponed by Judge John J. Sirica until September 18th to allow the 8 parties involved to retain individual counsel. Steinbrenner met the following day with 6 of the contributors and announced that he had retained counsel to assist the 8. Clark testified that at this meeting, Mr. Steinbrenner mentioned that he had wanted to go before the grand jury or before the committee, the prosecuting committee, then the Cox Committee, as did previous companies such as American and Braniff, I think are the names he mentioned. He wanted to do that, but he was advised not to. Other testimony indicates that Melcher was the advisor. The attorney retained by Steinbrenner met with Melcher, Slater, and the 8 contributors on September 11, 1973. He advised the 8 contributors that by signing the false FBI statement, they could be in violation of Title 18 United States Code, Section 1001, false statements to federal officers. The subject of immunity was brought up, and the attorney explained the general procedure for procuring it, and he advised them to retain personal counsel. On September 15, 1973, the entire group traveled to Washington, D.C., and with the help of Melcher, retained counsel from various Washington firms. The employees testified before the grand jury on September 18, 1973, under a grant of immunity. On April 5, 1974, Steinbrenner was indicted on 1 count of conspiracy under Title 18 United States Code Section 371, 5 counts of willful violations of Title 18 U.S. Code Section 610, 2 counts of aiding and abetting the making of a false statement under Title 18 U.S. Code 1001, 4 counts of obstruction of justice under Title 18 U.S. Code Section 1503, and 2 counts of obstruction of a criminal investigation under Title 18 U.S. Code Section 1510. Steinbrenner has entered not guilty pleas to all counts and is awaiting trial. The company was indicted on the same day on 2 counts, 1 count of conspiracy under Title 18 U.S. Code Section 371, and 1 count of a non-willful violation of Title 18 U.S. Code Section 610. The company has also pleaded not guilty. On April 11, 1974, Melcher entered a guilty plea to a 1-count violation of Title 18 U.S. Code Section 610 and was fined $2,500. End of Section 2. Recording by Maria Casper. Section 3 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. Chapter 4, Campaign Financing, Part 3. C. Ashland Oil Company, Incorporated. Ashland Oil Company, Incorporated, approximately 70th among American manufacturing companies, with assets of about $1.5 billion and annual sales of about $2.3 billion, made a $100,000 pre-April 7, 1972, cash contribution to the Finance Committee to re-elect the President. Orrin Atkins, Chairman of the Board and Chief Executive Officer of Ashland Oil Company, testifying at a public session, stated that in early March 1972, Maurice Stans, by telephone, asked for a $100,000 contribution for President Nixon's campaign, and further, that a $10,000 advertisement in the Republican Convention brochure be purchased. Atkins explained that after discussing Stans's request with the Ashland president and 2 of its vice presidents, he concluded that the corporation should make the contribution and purchase the advertisement. Atkins related that the money for the contribution was dispersed from their subsidiary, Ashland Petroleum Gabon Corporation, Gabon, Africa, and charged to an undeveloped leasehold sometime in late March 1972. The use of false vouchers and false bonuses to generate funds for this contribution was considered and rejected by Atkins and his colleagues. The Gabon subsidiary was used largely in order to prevent, or at least to postpone, taking the transaction as an income tax deduction. In late March 1972, William R. Seaton, vice chairman of the board of Ashland Oil, picked up $100,000 in cash in Geneva, Switzerland. It was delivered on April 3, 1972, by Clyde Webb, a vice president of Ashland, to Stans, who dumped it in his desk drawer and said thank you. Atkins explained why the decision was made to withdraw the money from the Swiss account. Well, $100,000 in cash is a commodity which U.S. banks, I do not believe, normally deal in from day to day. But I think the Swiss, being a more sophisticated financial society than ours, I believe, are used to dealings in such numbers, and it does not excite anybody's curiosity if you walk in and ask for $100,000 out of a Swiss bank. If you did that in the United States, everybody and his brother would be wondering what you did with it. Sometime in the spring of 1973, Stans told Webb by telephone that there was a list of contributors and that Ashland Oil was on it, and that he was trying to reconstruct the list and would like to have from us, Ashland Oil, any information that we could reconstruct. No response was made to Stans's request. Later, in a letter dated July 9, 1973, Kenneth Parkinson, counsel for FCRP, advised Atkins that he understood that Atkins had informed the Finance Committee that the contribution of $100,000 was made by Mrs. Atkins and himself. Atkins stated at that time he had not advised anyone on the Finance Committee who had made the contribution. Meanwhile, in a letter dated July 16, 1973, Ashland's counsel likewise informed FCRP of the corporate source of the contribution and requested that the $100,000 be returned to Ashland Petroleum Gabon Corporation. On the same date, FCRP transmitted a check for $100,000 payable to Ashland Petroleum Gabon Corporation to the company's attorney. When asked what were the reasons that prompted you to make the illegal corporate gift, Atkins responded, "Well, again, the situation today is difficult to rationalize. We were not seeking any particular privilege or benefit because we don't do any significant business with the government. I think all we were attempting to do was to assure ourselves of a forum to be heard. Were we a larger factor in our respective industries, we could expect to have access to administrative officials in the executive branch of government with ease. But being a relatively unknown corporation, despite our size, we felt we needed something that would be sort of a calling card, something that would let us in the door and make our point of view heard. We didn't expect those points of view to be accepted, but only from the point of view of being able to express them, and that was our thinking or rationale as to why we were interested in making any type of contribution." When questioned at public session, Atkins said that the contribution produced no distinctive benefit to Ashland Oil. Atkins included in this respect the subsequent action by the government lifting import quotas on foreign oil. However, he was shown a copy of a letter which he sent to a stockholder, which stated, "There was a good business reason for making the contribution, and although illegal in nature, I am confident that it distinctly benefited the corporation and the stockholders." Atkins explained the contribution's intent was to give us a means of access to present our point of view to the executive branch of the government. Although in view of the timing of events, Atkins said, no such benefits occurred. However, 3 days after the contribution, Ashland officials met with officials of the Office of Emergency Preparedness on the subject of obtaining greater supplies of crude oil. There is no evidence that the meeting and the contribution were connected. Atkins acknowledged that at no time did Stans state that he expected the contribution to be corporate, but stated, "I can't testify as to what Mr. Stans had in mind, but the minute he mentioned it, I knew it had to come from the company. $100,000 is an awful lot of money, and I knew what I had in the bank, and it wasn't anywhere close to that, and I knew what my associates had, and there was only one source that it could come from my point of view." Atkins said that as far as he knew, Stans had no reason to believe that he could personally afford $100,000. Stans did not threaten Atkins, and Atkins was under no obligation to Stans. The solicitation conversation took about 3 minutes, and according to Atkins, Stans said something like, "Mr. Atkins, I would like to have a donation." Yet Atkins felt under considerable pressure to contribute the requested $100,000. Atkins noted that this was the only request for a contribution from a former cabinet officer. Senator Ervin then addressed Atkins. Senator Ervin: "Mr. Atkins, it looks to me as if Mr. Stans had made an assessment." Mr. Atkins: "I think that is a correct assessment." Senator Ervin: "In other words, he told you, in effect, that he would let you off with a contribution of $100,000 plus a $10,000 advertisement in the convention paper." Mr. Atkins: "I believe you are right." Senator Ervin: "He never left you much option in the matter, did he?" Mr. Atkins: "I don't believe so. It is true that I didn't have much of an option." Senator Ervin: "Now, this question of maintaining the anonymity of contributions is a two-way street. It not only protects the disclosure of the fact of the identity of the contributor, but it also prevents disclosures of facts which would give a lead as to who raised the contribution and by what method it was raised." Mr. Atkins: "Yes, sir." Senator Ervin: "Mr. Stans made a great profession when he was before this committee that he was merely trying to conceal the identity of contributors. But do you not agree with me that the method, when you concealed the identity of a contributor, You also concealed a method by which you can find out how the recipient of the contribution got the contribution. Mr. Atkins: Yes. Senator Ervin: It is certainly a human weakness or desire for anyone engaged in business to have a friendly ear in government. Mr. Atkins: That is right, very much so. Senator Ervin: And so, departing from the realm of politics into the spiritual, this method of raising campaign contributions now borders on extortion, does it not? Mr. Atkins: Very much so. Ashland Petroleum Gabon Corporation was indicted for making a corporate contribution, and Atkins was indicted for aiding and abetting the corporation in making the corporate contribution. The corporation entered a plea of guilty and was fined $5,000, and Atkins entered a plea of nolo contendere and was fined $1,000. D. Braniff Airways, Incorporated. Braniff Airways, Incorporated contributed $40,000 in cash from corporate funds to FCRP sometime between March 28, 1972 and April 7, 1972. In a staff interview, Harding Lawrence, chairman of the board, stated that on March 1, 1972, in the presence of Daniel Hofgren, vice chairman of FCRP, he made an unsolicited $10,000 cash contribution to Maurice Stans. Lawrence identified the source of this contribution as $5,000 from his personal funds and $5,000 from the personal funds of C. Edward Acker, the president of Braniff. Lawrence said Stans thanked him for the contribution, but stated that he felt Braniff executives could do more because the company was doing much better than the rest of the industry. Stans suggested that a donation in the neighborhood of $100,000 would be more appropriate. Lawrence told Stans that he would see what could be done. Lawrence ultimately decided that Braniff could contribute $40,000. Because he was to be out of the country until just prior to the April 7, 1972 deadline, and because of the need to make the contribution before that date in order to avoid disclosure, Lawrence delegated the task of securing the funds to a group of Braniff executives. This group, consisting of R. H. Burke, Jr., Vice President for Public Affairs, John Casey, Executive Vice President for Operations and Services, Charles South, Vice President for Latin America, and Andrew J. Phelan, deceased, Vice President and Treasurer, devised a plan whereby Camilo Fabrega, Braniff's manager in Panama, would use CamFab, a Panamanian entity owned and controlled by Fabrega, as a conduit for obtaining the funds for the contribution. Phelan caused Braniff voucher number 083750, dated March 29, 1972, to be issued approving the payment of $40,000 to CamFab as an advance for expenses and services. A Braniff check was issued to CamFab and entered on Braniff's books as an account receivable of $40,000 due from CamFab. The check was forwarded to Fabrega, who endorsed it on behalf of CamFab and cashed it at a bank in Panama. He returned the proceeds in U.S. currency to Braniff officials in Dallas. Subsequently, Lawrence, Acker, and Burke delivered the $40,000 in cash to Stans. The account receivable from the Panamanian entity to the corporation was paid off and liquidated in the following manner. A supply of special ticket stock was placed in the hands of Fabrega. Tickets written upon this ticket stock were sold at ticket counters only by the supervisor in the Braniff Panama office, generally for cash. If a customer wanted to pay by check, regular tickets were used. The receipts were not accounted for as ticket receipts, but were applied to the liquidation of the account receivable from the Panamanian entity. Periodically, on his trips from Panama to the Dallas head office of Braniff, Fabrega would take several $1,000s in cash for delivery to Braniff. Fabrega described these deliveries as unusual. Since sales of controlled stock by December 1972 had reached only $27,000, and Braniff wanted to liquidate the whole account by the end of the year, Fabrega obtained a personal loan from a Panamanian bank for the remaining $13,000 in that month, and furnished the corporation with a bank draft for $13,000 out of these borrowed funds, thereby producing a total of $40,000, which liquidated the account receivable. Fabrega testified that he subsequently reimbursed himself for the $13,000 through the proceeds of additional sales of the uncontrolled ticket stock through early 1973. According to Braniff, no additional taxes were owed as a result of its corporate contribution. Revenues for the transportation of passengers are entered not on the basis of ticket sales, but on the basis of physical boardings of passengers with tickets. The fact that the uncontrolled ticket stock was sold and the receipts were not accounted for as ticket sales did not affect the corporation's reported revenues or net income for 1972, in view of the timing of the transactions and Braniff's accounting procedures. Only those ticket sales outstanding as of July 31st of any year are taken into income. Since the money was returned to the company by its officers prior to July 31, 1973, no tax consequences resulted. Sometime in March 1972, Stans contacted Lawrence by phone and advised him that as a result of the suit brought by Common Cause, it might become necessary to reveal the names of contributors, and requested a list of the names representing the contribution from Braniff. Shortly thereafter, Lawrence met Stans in New York and furnished him the names and addresses of 9 individuals. Apparently, not all of these people were made aware of the fact that their names were being furnished as the source for the Braniff contribution. On July 5, 1973, Kenneth Wells Parkinson, counsel for the Finance Committee to re-elect the President, forwarded a letter to Lawrence advising him that the committee may be required shortly to disclose the names which he had furnished to Stans. Since this created an immediate problem for Lawrence and Braniff, it was decided to contact the people who had been named and request that they give their personal checks to repay Braniff the $40,000 which had been contributed from unrecorded ticket sales. This was done, and Braniff credited the sum to an unearned passenger transportation account as a reimbursement to Braniff. No request was made of FCRP to return the contribution. On November 12, 1973, Lawrence and Braniff pleaded guilty to non-willful violations of Section 610. Braniff was fined $5,000 and Lawrence $1,000. E. The Carnation Company. The Carnation Company has acknowledged that a total of $7,900 in corporate funds was used in making 2 contributions to President Nixon's 1972 re-election campaign. Although company executives have conceded that they were under no pressure, implicit or otherwise, they felt that the presidential candidate preferred by a majority of the company's executives should be supported by a modest contribution from the company. This philosophy, company officials now say, has been rejected. The first contribution, $2,900, was made in June 1972 to the Finance Committee to re-elect the President. The solicitation was in the form of a mass mailing letter bearing the facsimile signature of Maurice Stans, which went to S.A. Halgren, Senior Vice President of Carnation, and at least one other Carnation executive. The second contribution, $5,000, was solicited by a Los Angeles civic leader who is executive officer of a local retailing concern, who contacted H. Everett Olson, chairman of the board of directors of Carnation, by personal letter or by telephone, requesting him to buy 10 $1,000 tickets to a Nixon fundraising dinner sponsored by the Southern California Presidential Committee to be held in September 1972. It was finally decided that only 5 tickets would be purchased for the dinner. Both the $2,900 and the $5,000 contributions were made by personal checks of Carnation executives, payable respectively to the Finance Committee to re-elect the President and to the Southern California Presidential Dinner Committee. The executives were then reimbursed in cash by Hallgren. According to Carnation, the personal checks of the executives were written by them with the expectation of reimbursement. Hallgren obtained the cash for the foregoing reimbursements from corporate funds by charging the $7,900 on the books as a travel expense to a transportation expense account. On December 19, 1973, the Carnation Company and Olson pleaded guilty in U.S. District Court to violation of Title 18 of the U.S. Code, Section 610, by consenting to the corporate contribution. The company was fined $5,000 and Mr. Olson $1,000. F. Diamond International Corporation. The Diamond International Corporation made contributions from corporate funds to two presidential candidates, Richard M. Nixon and Edmund S. Muskie, during the 1972 campaign. The contribution to the Nixon campaign came as a result of the solicitation of Raphael Dubrowen, Vice President of Public Affairs for Diamond International, by Vincent F. DeCaine, a former Diamond employee who was then Deputy Assistant Secretary of Transportation. Dubrowen, with the approval of Richard J. Walters, Chief Executive Officer, President and Chairman of the Board of Diamond International, had two checks drawn on Diamond's corporate account for $2,500 each. Both checks, the first dated February 23, 1972, and the second dated March 27, 1972, were made payable to the First National City Bank of New York. The bank, in turn, issued two $2,500 treasurer's checks to the Effective Government Committee of the Finance Committee for the Re-election of the President. A $1,000 contribution was made to Senator Muskie's campaign on December 14, 1971, based on a letter from Governor Curtis of Maine and a follow-up letter from Gus Clough, a business acquaintance and the public relations director of a Maine paper company, further soliciting funds for Senator Muskie. Mr. Dubrowen, in a telephonic interview with staff investigators, said a major consideration for making this contribution was that Diamond International had business dealings with the state of Maine. The mechanics of the transaction were essentially the same as in the Nixon contribution. On March 7, 1974, Diamond Corporation and Dubrowen entered guilty pleas to violations of Title 18 U.S. Code Section 610 in connection with the above illegal corporate contributions. The corporation was fined $5,000 and Dubrowen $1,000. End of Section 3. Recording by Maria Casper.
Section 4 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2, Section 4. G. Goodyear Tire and Rubber Company. Goodyear Tire and Rubber Company, prior to April 7, 1972, contributed $40,000 in cash to the Finance Committee for the re-election of the President. Russell DeYoung, Chairman of the Board of Directors and Chief Executive Officer of Goodyear Tire and Rubber Company, stated that the contribution originated in a conversation with Maurice Stans on or about February 16 or 17, 1972, in Washington, D.C. Stans told DeYoung that he would be contacting him about a contribution to the Finance Committee for the re-election of the President. In public testimony, DeYoung stated, "There was some mention of making a contribution prior to April 7th in order that it would not have to be publicly reported. I discussed the matter with Mr. Arden Firestone, Vice President of Goodyear. As a result of that discussion, Mr. Firestone, on March 9th, delivered $20,000 in cash to Mr. Stans in Washington, D.C. I did not attend that meeting, but was later informed that Mr. Stans did not ask and was not told the source of the funds. Mr. Stans said he had hoped for a contribution in the range of $50,000, but he did not state or imply that any pressure would be brought if a larger contribution was not forthcoming." It was decided that, in the light of Mr. Stans' reaction, an additional contribution would be made. An additional $20,000 in cash was turned over to Mr. Stans by Mr. Firestone at a second meeting in Washington on March 14th. On this occasion, 2 personal checks, one from my wife in the amount of $2,000 and the other from me in the amount of $3,000, were also delivered to Mr. Stans. I did not attend that meeting either, but understand that, as on the March 9th occasion, there was no discussion with Mr. Stans as to the sources of the contribution. DeYoung explained the source of the funds. The cash used in making the contribution came from volume discounts from suppliers of Goodyear's foreign subsidiaries. Such amounts were transferred to the United States through normal banking channels from an account maintained in Switzerland. I was never personally involved in the handling of these discounts. I am advised, however, that for a period of time prior to 1967, certain of our European suppliers were directed to deposit volume discounts in an account in a Zurich bank designated Goyeda, standing for Goodyear Deposit Account. From time to time, amounts were withdrawn from this account and kept under the control and custody of an officer of the company in Akron. No discounts were channeled into this account after 1967, when a new financial officer, B.M. Robertson, took over. The account itself was finally terminated in 1970. There is no longer any cash from this source in the custody of any company officials. The amount used in making the contribution was never entered on the company's books as income, and it was never taken on its tax return as a deductible expense. Mr. DeYoung explained the next contact with Stans. In April of 1973, Mr. Stans asked for the names of individuals who had made the $40,000 contribution in March of 1972. He stated that it was highly probable that the Finance Committee would eventually have to make public a list of the individual contributors. He said that the committee records merely showed that the contribution came from Goodyear employees. We first tried to get the money back, but Mr. Stans said that was not possible. After further discussions within the company, we decided to give Mr. Stans the names of 8 Goodyear executives, including my own, and divide the $40,000 among the 8. This was done with the approval of the executives, but with a clear understanding that they would not at any time become involved in any perjury. We gave the names because we thought the company might be harmed by the publicity if it became known that Goodyear had, as a company, made a sizable contribution to either political party. Mr. Dorson, did you personally ask the company executives if their names could be used in response to the request by Mr. Stans? Mr. DeYoung, I did. Mr. Dorson, and did each of the employees agree to have his name utilized in this connection? Mr. DeYoung, yes, they did, on the basis that they would not become involved. Senator Ervin, so he, Stans, was kindly supplied with the names of 8 men, corporate executives, who allegedly, or rather were posing as donors of this money when they had not given a single penny of it. Is that not correct? Mr. DeYoung, that is correct. Senator Ervin, so that was intended to... Who was that intended to deceive? Somebody. Mr. DeYoung, well, really, it was a delaying action. Senator Ervin, a delaying action that was given to Mr. Stans so that he could tell the court in the common cause suit that? Mr. DeYoung, no, when we were asked to confirm it, we denied that. Senator Ervin, I know, but as I get it, you say these men would not have gone and committed perjury, that they had been summoned and given, required, to take an oath telling the truth. They would not have committed perjury, but they were willing to have a false representation made that was not under oath. Is that not so? Mr. DeYoung, that is correct. Later, when Goodyear received a letter from CRP attorney Kenneth Parkinson asking for a confirmation of the information supplied to Stans, Firestone wrote him stating that they could not confirm the contribution as described. Shortly thereafter, Goodyear publicly described the illegal source of the contributions and asked for and received the return of the contributions. DeYoung explained why cash was used for the contribution. Senator Ervin, now, I will have to be frank to say I don't find your statement, the reason that this company sent this money in 2 payments of cash, very convincing. I spent a large part of my life as a lawyer, and I did much work for corporations, and I have searched my memory in vain since hearing your testimony, and I don't recall a single time that a corporation ever paid me a single penny in compensation for legal services, except by check. So wasn't there some reason different than the fact that you had cash, that you paid in cash? Mr. DeYoung: cash has a tendency to get lost. Senator Ervin: it particularly has a tendency to get lost from view, doesn't it, as compared to a check? Mr. DeYoung: that's right. Senator Ervin: so I would find it more convincing if you had stated that Goodyear sent this $40,000 of corporate funds down here by cash in order to conceal the fact that it was making a corporate donation. Now, is that not a fact? Mr. DeYoung: that is right. Senator Ervin: yes, fine. And they could have transmitted it down here. If it would have been a legitimate transaction, they would have transmitted it down here, in all probability by either sending a letter down here with a check in it and an 8-cent stamp, instead of paying the transportation cost of the vice president to and fro 4 times between Washington and England, would it not? Would that not have been the normal thing to do? Either that, or let the bank in England, or whatever other bank you had down here in Washington, let them issue a check for it? Mr. DeYoung: that is normal business practice, yes. Mr. DeYoung conceded that publicity motivated the disclosure of the corporate contribution to the special prosecutor. Senator Weicker: did you step forward and volunteer information to the prosecutor after American Airlines did it? What motivated you to step forward at all? Mr. DeYoung: because of the publicity we were getting, and we found out then that it was very, very serious what we had done. Senator Weicker: well, the degree of seriousness didn't change. It was serious when you did it. So it was a matter of being discovered or the publicity that was of concern to you. Mr. DeYoung: that is right. Senator Weicker: has any judgment been passed on Goodyear? Mr. DeYoung: there has. Senator Weicker: what does that consist of? Mr. DeYoung: October 17, 1973, the Special Watergate prosecutor staff filed in the U.S. District Court for the Northern District of Ohio an information which charged both the company and me with having committed misdemeanors in violation of Section 610 of Title 18, United States Code, by making and consenting to a $40,000 contribution in connection with the presidential election of 1972. The company and I pleaded guilty to the charges. Maximum fines which were assessed by the court have been paid, both by the corporation and myself. Senator Weicker: what fines were assessed? Mr. DeYoung: $5,000. The maximum fine was $5,000 to the company and $1,000 to me. Senator Weicker: and the shareholders will all be sharing in the paying of the $5,000 fine, is that right? Mr. DeYoung: what do you mean? Senator Weicker: well, the $5,000 fine was paid by the corporation, so in effect all the shareholders are involved in the paying of the fine, is that right? Mr. DeYoung: that is correct. Senator Weicker: even though the shareholders weren't consulted as to whether or not they thought the reelection of the president was in the best interest of the country, nevertheless, they are going to pay for the actions of you and Mr. Firestone, is that right? Mr. DeYoung: well, they pay for all actions of the corporate decisions that are made. Senator Weicker: well, I would say it is a pretty sorry day for Goodyear, wouldn't you? Mr. DeYoung: not necessarily. Senator Weicker: of course, again, it is only a matter of publicity, not of principle, that had you stepped forward and has you before this committee. Is that correct? Mr. DeYoung: that is probably correct. H. Gulf Oil Corporation. Gulf Oil Corporation, a company with annual revenue of $9 billion, prior to April 7, 1972, made cash contributions of $100,000 for the re-election of President Nixon and $10,000 to Senator Jackson and $15,000 to Congressman Mills, respectively, for their campaign in seeking the nomination as the Democratic candidate for president. Claude C. Wild, Jr., Vice President for Government Relations of Gulf Oil Corporation, stated, "In early January or February 1971, a Mr. Lee Nunn came to my office or visited and informed me that there was being set up a committee to re-elect the president and that they would handle the campaign outside of the normal Republican channel, which he meant the Republican National Committee, and Mr. Nunn was hopeful that I could arrange to get $100,000 in their hands one way or the other. He suggested if I wanted some verification of his legitimacy of his role in the operation, because this was a new role for him. He had been up here, as you know, with the Republican Senatorial Campaign Committee for any number of years, and Mr. Nunn suggested that if I wanted verification for his participation in this role, that he suggested that I contact Mr. Mitchell, because he was going to be active in the strategy part of the campaign, and Mr. Stans was going to handle the finances." Wild related that he and a friend, Jack Mills, met in the Justice Department with then Attorney General Mitchell, who indicated that this was an operation such as the Committee to Re-elect the President, that Mr. Nunn was going to participate in that he had full confidence in Mr. Nunn, and that is about it. Wild was aware of the importance of the April 7th date, the day when the disclosure law became effective. Wild stated that, without consulting anyone at Gulf, he decided to give $50,000, and that I had to find a place for the money, where the money was, so I called the controller of one of our companies in the Bahamas, and I told him I needed $50,000, and he brought it to me. He explained that the man's name was William Delia, and that the company was the Bahamas Exploration Limited, a subsidiary of Gulf, which is no longer in existence, and that the $50,000 was charged to miscellaneous expense account. Wild related that Delia delivered the $50,000 in cash to him, and that in April or May 1971, Nunn was given the cash in Wild's office. Wild stated that he was contacted again by Nunn in January 1972 for an additional contribution. Mr. Wild: Well, I think he came to my office again and indicated that this would be a very expensive campaign and that they wanted more money, and he would like another $50,000, making a total of $100,000, the implication being to me, and I cannot remember whether he made that exact statement or not, but the implication was that this was kind of a quota that they were expecting from large corporations. Mr. Dorson: What was the result of that meeting? Mr. Wild: Well, he suggested that I might like to visit with Mr. Stans about this, which I did. He set the appointment up. This was, not my records, but their records indicated that it was the 4th of February, which was after, probably while Mr. Stans was still Secretary of Commerce, but after he had announced he was going to resign. I met with him for about 15 minutes. Mr. Dorson: What occurred at this meeting? First of all, who was present? Mr. Wild: Just Mr. Stans and myself. Mr. Dorson: And what was said? Mr. Wild: Well, he indicated that he was hopeful of obtaining $100,000 from the large American corporations. Ours being one of the top 10, he hoped that we would participate. He knew of the previous $50,000, and he said he would like $50,000. Mr. Dorson: What did you tell Mr. Stans? Mr. Wild: Well, I told him I would see about it. Mr. Dorson: What did you do after that? Mr. Wild: I contemplated it a little further, and I guess I made another mistake and said, all right, I will do it. So I called Mr. Delia again and got the money, delivered it personally to Mr. Stans. By that time, he had moved to his office in the Committee to Re-elect the President. Mr. Dorson: Did you deliver the money to Mr. Stans? Mr. Wild: I did, in person. Wild was asked why he considered it necessary to make such a large contribution. Senator Ervin: You said you decided it would be in the best interests of Gulf to comply with the request made by Mr. Nunn after being requested to make a contribution. How did you figure that? Mr. Wild: That was the decision I arrived at. Senator Ervin: Yes. How did you figure that the best interests of Gulf would be promoted by making a contribution? Mr. Wild: Well, Senator, you have to make decisions in the context of the situation that existed at the time. I arrived at the decision that if we were going to be treated in an equal way, I knew other corporations were going to, a big effort was going to be made, and if there was not some participation on my part or our part, we may be, whether you call it a blacklist or bottom of the totem pole, I would just like to answer my telephone calls once in a while, and that may not happen sometimes. Senator Montoya questioned Wild about the meaning of the term pressure used by Gulf in a press release issued at the time the company admitted making its illegal contributions. Senator Montoya: I will quote from this press release as follows. Third paragraph. These contributions were made in response to persistent requests to Gulf's Washington representative, Claude C. Wild, Jr., from representatives of the Finance Committee to re-elect the president. The company was not seeking any special favors and did not have any corporate activity under government scrutiny. There was enormous pressure in the political system, and the fact that others apparently also yielded is evidence of this. This pressure was intense. Now, was Gulf Corporation correct in making this evaluation of the kind of pressure that was applied? Mr. Wild: Well, we were talking in the release about pressure in the whole political system. Senator Montoya: How would they know about the other pressures and not know about the pressure that was applied to you? Mr. Wild: This was written after they found out about the pressures. I did not disclose any of this information to anyone prior to. Senator Montoya: Well, were they not directing the context of the statement to the pressure that was applied as a basis for their corporate funds being used in the contribution? Was that not the main thrust of this release? Mr. Wild: The first thrust of the release, I think, was that there was pressure in the system on me as a representative of the corporation. Senator Montoya: Yes. Now, what kind of intense pressure was applied to you by these individuals? Let us start with Mr. Nunn, and then let us continue with Mr. Stans. Mr. Wild: I guess the wording here, intense pressure, is subject to various interpretations. But in my days, I considered it considerable pressure when 2 cabinet officers and an agent of one of the committees that was handling the election asking me on various occasions that I have enumerated, the times that I have enumerated, asking me for funds. That is just a little bit different than somebody collecting for the Boy Scouts. Senator Montoya: In other words, having been around Washington for quite a bit, you read the message. Mr. Wild: Well, I thought I had a message. Responding to questions from Senator Ervin, Wild testified. Senator Ervin: Mr. Wild, don't you think it is very unfortunate that we have so much regulation of business in America that business necessarily is susceptible of being coerced by people in authority to make a campaign contribution, which, if left to themselves, they certainly would not make? Mr. Wild: I could not have said it better. Senator Ervin: Don't you agree that Congress should give serious consideration to making it a criminal offense for any official clothed with great governmental power to solicit or receive a campaign contribution? Mr. Wild: Senator, I don't think I would be prepared to go quite that far. There is certainly the right of an individual to do whatever he pleases with his money. Senator Ervin: I agree with you on that, but this is a different question, I think. Here, for example, is an Attorney General of the United States who has so much power, and in large part discretionary power over American business. Mr. Wild: That is right. Senator Ervin: And likewise the Secretary of Commerce, which in many cases is discretionary in nature, that when he requests a campaign fund, it is almost a coercive practice, isn't it? It is quite close to it, isn't it? Mr. Wild: Well, that is the way it came through by brain, anyway. Mr. Wild stated that sometime in the spring of 1973 he met with Nunn, who informed him it may be necessary to disclose the names of the pre-April 7th contributors and that Wild should be prepared to give names. Wild testified as to what happened next. Then Secretary Stans called me, and he wanted to know how the $100,000 contribution should be. He expressed again a concern at this matter. He regretted it very much because these contributions were supposed to be made where no disclosure would be made. He was very apologetic and so forth. But at the same time, he said, it looks like we are going to have to make a listing of these contributions made prior to April 7th. He asked me how I wanted it listed. I told him that, well, I didn't have any names to give him, so I said Claude Wild and Associates. Stans called Wild a second time, and Wild gave him the same response. Mr. Dorson, were you thereafter contacted with respect to this information again? Mr. Wild, the next contact I had was in a letter dated July 9, 1973, from Mr. Kenneth Parkinson, who was the counsel for the Finance Committee, asking me to verify the fact that $100,000 contribution had been made and the proper showing on their listing should be employees of Gulf Oil Corporation, Mr. and Mrs. Claude Wild. It was at that point that I thought things were sufficiently of a serious nature that I arranged a meeting with the chairman of the Gulf Oil Corporation, Mr. Dorsey, and discussed this matter. Then we obtained counsel in a short period of time, made a disclosure, voluntary disclosure, to the then Cox Committee, and requested our money back from the committee to re-elect the president, which we did obtain. In connection with the corporate contributions made to Senator Jackson, Wild gave the following testimony. As I recall the time frame, it was in early January, could have been February of 1972, I was contacted by Mr. William Brawley, Bill Brawley, who is on the staff of Senator Jackson. He called me 2 or 3 times. My intuition told me what he was calling about. Finally, I agreed to meet with. He wanted to arrange a meeting with me with Senator Jackson. Subsequently, that meeting did take place. I met with Senator Jackson and his assistant, Sterling Monroe. At that time, Senator Jackson indicated that he was having a difficult time raising money, and this was well documented, at least by the press, and he was hopeful that I would be helpful. I told him I would see what I could do. What I did was arrange, through the same sources, to get $10,000 and delivered it to Sterling Monroe. That is the last I saw of Senator Jackson or Sterling Monroe. Mr. Dorson, is it your testimony that Mr. Brawling called you and contacted you for the contribution? Mr. Wild, that is my testimony. Mr. Dorson, and is it your testimony that the subject of money was discussed at the meeting that you just described? Mr. Wild, no specific sum, but when you say, a politician says to someone, I hope you will be helpful, you kind of understand what that means. Mr. Dorson, but no sum was discussed at that meeting? Mr. Wild, no sum was discussed. Gulf Oil Corporation and Wild were fined $5,000 and $1,000 respectively for making illegal corporate contributions to the presidential campaign of President Nixon. End of section 4.